Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer ownership of probate assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning and several stops along the way, and at the end of the trip, the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. In the show tonight, we will learn the nuts and bolts involved in probating an estate in Maryland. We will also review the role of the county register of wills throughout this probate train ride, from the time you legally qualified to act to when you wrap up the estate and distribute all the assets to the beneficiaries. And we will highlight important duties and deadlines to keep in mind during the course of your journey. With us tonight is a Maryland trust and estate attorney who will share his expertise and guidance on this topic. With me today is the managing partner in the Rockville law firm of Joseph Greenwald and Lake. He earned his BA from the University of Chicago and his JD from the University of Colorado School of Law. His practice focuses on estate planning, administration, and taxation issues. And he has more than 25 years of experience helping families through the Maryland probate process. Please welcome attorney Paul Rieckhoff. Hi, Paul. Thanks for joining us today.
Hi, Richard. I'm glad to be with you.
Well, let's begin. We had this discussion, during the pre-planning for this program. Let's just talk about what assets get probated in a probate.
Sure. And they'd be Maryland assets that are owned by the decedent, the person who's passed away, that are in their name alone and don't have another means of transmitting themselves to the beneficiaries of the estate.
So to just contrast that, then what assets do not get probated?
So assets that have beneficiary designations on them, such as a life insurance policy or an IRA, assets that are jointly titled with right of survivorship. So if two spouses own a house together with right of survivorship, or as tenants by the entirety, those assets will take care of themselves without the need for the probate process.
Okay. And again, so people understand, why is probate really necessary?
It's necessary for several purposes. One is to make a will valid. So when someone writes a will during their lifetime, that will sits and doesn't have effect until a court or an administrative body gives it effect. So the probate process makes the will valid, indicates that it governs the estate and the distribution of the assets, appoints a personal representative to handle the estate matters and follow the dictates and requirements of the court and the register of wills, and ultimately distribute the assets. It's also needed if a person doesn't have a will similarly to appoint a personal representative to manage the estate and to indicate that there is no will, call for a will, put out a public notice letting people know that there isn't one, and giving them the opportunity to bring one forward if they think there is a will that should govern the estate. So that's why probate is necessary. It's a start to finish process to help get the assets through the decedent's own possession and into the hands of the people who should receive them after the death.
Okay. So we talked about in Maryland, there's the Office of Register of Wills. Okay, so and they have a very important role in this whole process. So tell us what their role is.
Sure, they oversee the entire process. There are two bodies: the Register of Wills, which there's a separate register for each county in the state. The register themselves is an elected official. And then they have staff that depends upon the size of the county that helps administer estates. Then there's what's called the Orphans Court, which is the probate court in Maryland, which oversees contested matters, signs court orders to make certain aspects of the probate process final, et cetera. So the Office of the Register of Wills is the entity, the administrative entity with which you file a petition for probate. It's where you file an original will. It's where you file inventories and accountings. They take all that in, they oversee it, and ultimately guide the personal representative in terms of the administrative process in the estate by making them aware of their duties and requirements. They also are the entity in Maryland that collects the Maryland inheritance tax. So for an estate that has an inheritance tax issue, that petition is filed with the Register of Wills and where they assess the tax.
So I would want to call to our viewers' attention that I think we're showing on the screen the Register of Wills has a self-published booklet on administering estates in Maryland, which is fairly extensive. When I just refer folks to take a look at that. And there's also a nice little pamphlet I also was able to download that kind of summarizes, the entire process and things you're going to face very succinctly in a little bifold pamphlet. So something for folks to keep in mind. And we'll come back to that. So Maryland apparently has different types of probates, and we're going to focus on one of those. But just tell me, what are the three different types of probates that you have in Maryland, just briefly?
Sure. There are small estates in Maryland which are determined to be small based upon the assets that require the probate process. For most estates, that's a estate with $50,000 or less of assets. However, if there is an estate where the only legatee of the estate is the surviving spouse, so there's a will and the sole legatee is the surviving spouse, an estate up to $100,000 can be administered as a small estate in Maryland. Then there are regular estates, which is for every other estate that exists in Maryland. So estates that are larger than that, dealing with Maryland assets for a Maryland resident, Maryland domiciliary. And then there's a form of a regular estate called the modified administration process, which is a process that allows someone an estate to elect to proceed under truncated procedures for the administration process, but it's limited in its scope.
Okay. So Paul, before we leave this particular section though, some people may not actually be Maryland residents. They may be a resident of another state, but may have some assets in Maryland that need to be probated. Now, I know we're going to have a conversation about that in another show, but maybe you want to mention a little bit about what that is and what we'd have to do, just very, very briefly, to probate those assets for that person who lives outside of Virginia, outside of Maryland, I mean.
Certainly. For that type of situation, Richard, in Maryland, a foreign estate proceeding would be established, which is a very simple form of a probate proceeding in Maryland. Doesn't involve a lot of interaction with the Register of Wills, et cetera. It's basically has a notice requirement in the jurisdictions in which property in Maryland exists, as well as making sure taxes and claims get satisfied for the non-resident decedent.
Okay, well that's good to know. We want to keep that in mind because a lot of folks own beach property along in the Maryland beach area, and and they may live elsewhere, so we want to make sure we know about that. Well, let's switch gears and go to the next thing, which is we have we're going to focus on the regular estate, which you mentioned is one of the probate estates that are available in Maryland. And let's talk about that now. I want to get the personal representative qualified. So what is the process to get that person qualified to go ahead and start the probate process for a regular estate in Maryland?
Sure. Well, that person would need to complete a petition for probate in Maryland, which is a petition that indicates who passed away and where they died, their date of death. It indicates who the petitioner is, who wants to be the personal representative. It lets the Register of Wills and the court know whether at the time of the death of that person, they had any other legal proceedings going on, such as a divorce matter, et cetera, that the court needs to be made aware of. It indicates whether there's a will or not, and whether there are any codicils or amendments to that will that are being filed, and it states the names of the witnesses of the wills. It gives an estimate of the estate that is anticipated to be probated in Maryland, breaking it down into real property or real estate segments and personal property, which can include anything from tables and chairs to bank accounts, stocks and bonds, et cetera. It will also give an indication as to whether the personal representative anticipates the inheritance tax to apply to the estate. So all that gets included in the petition for probate, and it's signed under oath by the personal representative and then submitted to the Register of Wills along with an original will and original codicils if they exist, and some proof of death, which is typically in the form of an original death certificate, which the Register of Wills just uses to confirm that the person that we're trying to probate an estate for has actually died, and then they return it. It doesn't become part of the public record. Typically at that time, also a list of interested persons is filed with the register that indicates who who is involved in the estate, and what that comes down to is it states who the personal representative is again and gives their address and a relationship, if any, to the decedent. It indicates the legatees of any will, those are the beneficiaries of a will, and their names and addresses and the relationship that they have to the decedent, if any. And it indicates the heirs at law, whether there is a will or not. Those are the people who would inherit from an estate if there wasn't a will. And it gives their names and addresses in relationship to the decedent.
So I'm going to sort of stop you there. So I think the one thing I was very happy to see is that apparently Maryland has a lot of these forms that you need to complete to start this process on the website of the local Register of Wills, so that a lot of this stuff doesn't require original drafting by an attorney. It's just basically, to some extent, filling in the forms, though they have to be filled in correctly.
That's correct. There's a very comprehensive set of forms on the Maryland Register of Wills website that are very, very useful in this process.
Now, so I need to qualify. We've got all these documents together. How do I figure out what office I'm supposed, which Register of Wills I should go to?
Well, generally speaking, it would be the main probate matter would be opened in the jurisdiction of domicile of the decedent. So where they live, where they considered the county in which they considered themselves to be a legal resident, where they voted, et cetera. That's where probate would typically be opened. There is the ability under Maryland law to open it in another jurisdiction if that made sense. For instance, if a person rented an apartment, let's say in Montgomery County, Maryland, but they had a home and a business over at the beach, for instance. So they had a beach house that they would go to sometimes, and they had some sort of a business over there. It might make more sense to open that probate matter in the jurisdiction where those assets are located as opposed to where they're domiciled, but that's relatively rare.
Okay. And then once I go through that process, eventually I get some document that indicates I've been approved to act as a personal representative. That document is called what?
It's called the Letters of Administration,
okay.
Which is a document that bears the seal of the Register of Wills that allows a person to go forward and interact with the decedent's banks. They'll take that in and understand that they're dealing with the appropriate person under the law for the access to liquidation of and distribution of the decedent's assets.
Okay. All right, so we'll go to our next topic, which you touched on a little bit, but we just want to follow through on that. And there's various notices and publications that need to take place as part of the process to put people on notice that someone has died and that their estate's now being probated. So I know you mentioned initially that we typically, the list of interested persons is completed as part of the submissions to go in when you get qualified. Although you have, I guess, 30 days in which to get that in. Normally it goes in by the time you qualify. Now, so the purpose behind that is to identify all the folks who should be notified. Is that correct?
That's correct. And along with that, you also file at the time that the petition is filed a newspaper notice that will get published in a newspaper of general circulation, and each register has a listing that of newspapers that qualify for people who want to figure out where the appropriate place to do that is. And that notice gets submitted to the Register of Wills, completed as much as the personal representative can, and the personal representative will sign that. And then the Register of Wills will fill in certain dates by which creditors have to come forward and file claims against the estate. It'll indicate when the probate matter was opened and then give timelines for people to contest the appointment of a personal representative or the acceptance and probate of the will.
Okay. So, but folks generally, if they want to challenge something, they have 6 months in which to do it. Is that correct?
That's correct. Yeah,
Okay.
from the date that the probate matter is open. And for people who are on that list of interested persons, the registrar will then send them certified correspondence letting them know that the estate matter has been opened, where they can get information about the matter, you know, the estate number at which they can find things online or in the Register of Wills office, the name and address of an attorney, if any, and of the personal representative.
Okay. All right, let's move now to the court filings that that come into play for a regular estate. So again, a lot of these forms, or most of these forms, are all posted on the Register of Wills website. So the first one I want to talk about is there an inventory that's due. It's due. So tell me a little bit about when it's due, what is the purpose of that filing?
Sure. The inventory is due 3 months after the personal representative is appointed and the probate matter is open. And the purpose of that is to take the estimate of assets that I mentioned that is given to the register upon the opening of the probate matter and make it very specific. So in that 3-month period of time, it's expected that the personal representative will come forward and marshal all the various different assets, figure out what they are, and come up with the appropriate date of death values to submit to the Register of Wills. And different types of assets are valued in different ways. Bank accounts, it's the balance that's on a bank account statement as of the date of death. Stocks and bonds, it's a fair market value, an average of the high and low of the day on the date of death. For assets like real estate in Maryland, you have 2 options. One is to use the tax assessed value for that property. So the State Department of Assessments and Taxation regularly assesses valuation of real estate in Maryland, and you're allowed to use that date for the appropriate time period. Or you can have the property appraised by a competent and qualified appraiser.
Okay. Now, there is also, I guess the next thing is there is an information report that also needs to be filed, and I guess that typically is not filed. Is that typically not filed until after you've done the inventory?
It's generally filed at the same time as
Okay.
inventory. The due date is the same, 3 months after appointment. And the idea with the information report is to let the Register of Wills know about non-probate assets, assets that don't go through the Maryland probate process, for which there might be inheritance tax due.
Okay. Now, the next filing that I have on my list from our discussion is that there is an accounting due about 9 months after that person has qualified. So tell me a little bit about what the accounting is supposed to accomplish.
Sure. The accounting is a to the penny account of everything that's happened with the decedent's assets from the time that the administration was opened. So the account will start with a recitation of the inventory values of all the various different assets, and then it will list all the income earned, capital gains and losses incurred if assets were sold or disposed of. It will detail all the administrative expenses that have been incurred and all the debts of the decedent that got paid. And it will show any distributions that have happened as of that time. And finally, it'll end with a balance that's on hand at the end of that accounting period.
Okay.
If that's a final account, it'll be 0. But if the probate matter is continuing, then it'll list the assets that are still subject to it.
Okay, and of course, I was interested to learn that if you don't file it on a timely manner, there's a process to be notified to say where's your accounting, and if you don't do certain things, then things can happen with the court. So we want to make sure we get that timely filed, or at least get an approved extension. Let's talk about real quickly creditors of the estate. I was very interested to learn that basically the creditors' ability to collect on their debt has a very short time period.
Yes, it does. It's actually in Maryland, it's triggered on the death of the decedent for anyone who has a probate estate in Maryland. So they have 6 months, a creditor will have 6 months from the date of death, regardless of whether a probate estate has been opened.
Very interesting. So, and so those creditors, as we talked about, need to file something early on, okay, to at least establish the fact that there's an obligation, so that way can toll the statute of limitations.
That's correct. And they have the ability to file even if a probate matter isn't open. So the Register of Wills will take a claim against an estate that's yet to be opened.
Okay, but that's good to know as well. I don't want to run out of time without talking about the ugly topic of taxes. Okay. Okay, so there are tax filings, as we know. I mean, certainly the personal representative wants to file the final 1040, Maryland individual income tax returns. There may be a federal estate tax return. There may be some state income tax returns as well. But I want to talk about, there is something called, and we would mention it briefly, a merited inheritance tax return. Can you talk a little bit about that and how painful that tax is?
Sure. Yeah. It's a tax that a lot of people wish didn't exist. There's no doubt about that. It is a flat 10% tax nowadays. For people who died much longer ago, there were other gradations of the tax and applied at different levels. But now it's a 10% tax on the right to inherit property from a decedent from which you were not closely related or to which you were not closely related. So most people, most natural beneficiaries are exempt. So spouses, children, grandchildren, et cetera, including stepchildren, step-grandchildren are all exempt. Parents and step-parents are exempt. Grandparents are exempt. And brothers and sisters are exempt from the tax. But everyone else, aunts, uncles, nieces, nephews, cousins, friends, they're all subject to the Maryland inheritance tax, which is, as I said, a 10% flat rate.
Okay, and then of course the federal estate tax has a fairly high exemption amount, but I gather there is a Maryland estate tax return required if it turns out your gross estate's more than $5 million?
That's correct, more than $5 million. That return's called the MET1, which is just an acronym for a Maryland state tax return. And it has the same due dates as the federal estate tax return, which is 9 months after death. And like income tax returns, most of the work is done on the federal form. So even if a federal estate tax return is not required to be filed, you have to complete it in order to complete the Maryland estate tax return, and it's a required exhibit to the return.
Okay. So we're going to start to run out of time here, so I want to talk about distribution to beneficiary. Generally, I gather from our conversations in preparing for the show, you don't need to go to court to get any particular blessings, okay? So we just make the distributions, and I guess the process to file a final accounting is you just file the accounting, and there's a fairly short period of time the court where the exceptions can be filed, and then the accounting is done. Is that accurate?
Yeah, so in Maryland, personal representatives have the general authority to distribute assets. They do need to be mindful, however, that there is a period of time in which their appointment can be challenged, in which the will, if there is a will, can be challenged and potentially done away with if there's some problem with it. Creditors have the ability to come forward for 6 months, so they need to be cautious about the distributions they make prior to the termination of the probate process, to be certain. In terms of the final accounting, it's another account that gets filed with the court. It goes to the Register of Wills. They audit it, and assuming they accept it, they'll present it to the court. The court will sign an order, and then there's a 20-day period of time, as you mentioned, for exceptions to be filed to that particular order, after which the account becomes final and the matter becomes final.
Okay. Well, we're down to the last couple of minutes of the clock that I was told existed at the outset of this show. So very quickly though, do you think that a fiduciary in Maryland should hire an attorney or CPA to help them get through and deal with all these details?
Well, that's a good question. They're not required to under the law, but it certainly is a good idea for most people to get the help of competent professionals. There are many pitfalls along the way and opportunities that can be missed as well. And having that sort of professional advice and guidance is very useful.
Well, Paul, I want to thank you for taking the time to visit with us today and share your expertise and insights about the Maryland probate process. A great public service to everybody, especially the people the citizens in the state of Maryland. So thank you again for coming in to talk with us.
You're most welcome. Thank you for having me.
You bet. Without a doubt, Maryland probate can be complicated and confusing. The local register of wills is where you become authorized to drive your Maryland probate train. And their website contains numerous useful guides, forms, and checklists on Maryland probate, especially their basic instructional guide on administering estates. There's much you may be able to do on your own during the course of your probate journey, but we cannot stress this enough that there are many steps that require the guidance of an experienced attorney. We strongly recommend that you get that guidance early so that your entire probate train ride goes smoothly. This brings us to the conclusion of our show. I hope you found this show helpful should you probate an estate in Maryland. Keep in mind that replays of this show and all shows today can be viewed on the Probate Nation website. And we also encourage you to go to the Probate Nation website to sign up to receive the monthly newsletter on this and many other probate topics. Finally, we're done for tonight. Thank you very much for visiting with us. On behalf of the Probate Nation, thank you for visiting with us.